I'm Tom Kading, and I'm an attorney at Fargo Patent and Business Law. If you have a business dispute with a partner, your best approach is to try and settle it quickly without going to court. Litigation and legal expenses can become very significant if disputes cannot quickly be settled. If sending demand letters and responses can even be costly. I like to recommend 3 key things to clients when they are facing a dispute with a business partner. First, it is always good practice to discuss the situation with your attorney. First, this discussion shouldn't be about how you could sue the other party or how you would be sending a demand letter. Rather, this meeting should be to educate you about some of the legal issues facing the situation. In this attorney meeting, the goal should be to learn what things you should communicate and what things you really shouldn't communicate. Further, it is important for you and your wallet to have an attorney that isn't just going to haul off and sue someone or make the dispute worse by sending an inflammatory letter. So secondly, if you have a dispute that you and your attorney believe can be resolved, keep communication open and keep talking. You should continue to make normal communication with the other party. You shouldn't just begin shunning them and avoiding them. As you continue to communicate with the other party, make sure you are following the guidelines discussed with your attorney. If you are confident, try to meet with the other party at a mutual location to specifically discuss the situation and the possible resolutions. If you and your attorney do not feel the situation is resolvable by continued communication, you and your attorney will have to establish an alternative plan. And thirdly, consider a meeting between the parties with attorneys present. In this meeting, I suggest you ask the attorneys to mainly allow the parties to communicate their issues and the nature of the dispute. The attorneys can be present to help provide support and input as to how a settlement can be reached. Regardless as to if the attorneys are present or not present, if you reach an agreement, get it in writing, do it as quick as possible. If the writing gets delayed for weeks, it's not uncommon for a resolution to fall apart and never be signed off on. Each situation is different, and in some disputes, the proposed communication methods may work, and in other cases, these methods may just not be applicable. It is understandable that a dispute involving attorneys can increase anxiety. Clients are likely experiencing some uncertainty and don't fully know how to move forward. What attorneys can do is clearly lay out the options and the possible ramifications to those options. It is our job as attorneys to help calm our clients' anxiety by helping reduce the level of speculation our clients contemplate. All of our attorneys have experience running businesses and understand business. This unique trait can help bridge the gap between the needs of business and the needs of the legal system. Again, this is Tom Kading. I'm an attorney at Fargo Patent and Business Law.